Hi, it's Miss Morgan. Can't stop, won't stop civics. I will be reading the judicial branch reading that goes with one of your assignments is from the textbook that we use sometimes, We the People. All right, what powers does the Constitution give to the judicial branch? To complete the system of separation of powers, the framers planned for a judicial branch. A national judiciary was needed to decide disputes between state governments and between citizens of two or more states. It was also needed for disputes between the national government and a state or citizen. The framers had few problems agreeing on the powers of the judicial branch. Article 3 of the Constitution establishes the judicial branch. Article 3 includes the following ideas about the national court system. Number 1, judges should be appointed, not elected. Thus, judges would be independent of politics. They could use their best judgment to decide cases and not worry about the influence of political pressures. Or, this is not in the reading, but my own comment that they would not have to worry about getting reelected, which is why it says judges would be independent of politics. They could just decide the case and ideally not be worried about getting reelected back into their job. All right, number 2, judges should keep their positions during good behavior. Judges cannot be removed from office unless they are impeached. Then the judge would have to be tried and convicted of treason, bribery, and other high crimes and misdemeanors. This means that judges should be able to make decisions without fear of losing their jobs. It also means that judges can keep their jobs for life. Number 3, there should be a single U.S. Supreme Court with two types of jurisdiction. Jurisdiction means the power or authority to hear cases and make decisions. The types of jurisdiction are original and appellate. The U.S. Supreme Court has original jurisdiction in cases involving a state government or an ambassador. Original jurisdiction means that these cases go directly to the U.S. Supreme Court. A lower court does not try these cases first. In all other cases, the U.S. Supreme Court has appellate jurisdiction. The case is tried first in a lower court. Then the decision of the lower court is appealed to the U.S. Supreme Court. The Supreme Court may decide whether to hear a case on appeal. The Constitution clearly gave the U.S. Supreme Court the power to overrule state laws that violate the Constitution or the laws made by Congress. The power is based on the Supremacy Clause in Article 6. You will study the Supremacy Clause in Lesson 17. That's probably doesn't pertain to you. The national government is supreme in those areas where the Constitution gives it the power to act. For example, suppose a state passes a law allowing factories to pollute the air. Then Congress passes a law controlling the pollution a factory can produce. The national government's laws would have to be obeyed over state laws. Lastly, Washington, Madison, and the other framers who agreed with them got the strong national government they wanted. But the battle was not yet won. Many people in the U.S. were still afraid of a strong national government. They believed that it would be a threat to their rights and to their state governments. If you need to go back to a different point in the video, do that, press pause, or whatever. Maybe you already have done that. All right, that is it for my video.